the appeal hearing of the Ensign Hospitality Bill file number 25002. The denial of a class 2 permit for guest lodge file number 24-063 to order. See, if that's better.
That's fine.
Oh, thank you. Letting me know. Want me to go through that all again? Okay, I'll be happy to. Apologize, I thought the mic was already on. This time, we will call to order the commissioners' appeal hearing, or the appeal hearing to the county commissioners of the Ensign Hospitality Appeal, file number 25-002 of a denial of a class 2 permit for a guest lodge, file number 24-063. My name is Blake Hall. I am the county's civil attorney, and I have been asked to serve as the hearing officer for this proceeding. We want to welcome you all here and make sure that you know the procedure we're going to follow today. And as all of you are probably aware, this is a hearing where you'll be providing testimony to the Board of County Commissioners. At this time, I would ask everyone, including myself, to please silence your cell phones. We're not as bad as if I'm in court and my cell phone was off, the judge will find me, but we would, as a courtesy to everyone, ask that we turn off the cell phones so as to not to allow this hearing to proceed as expeditiously as possible. As I stated, the purpose of this hearing is to consider the appeal by Ensign Hospitality of the denial of their permit. At this time, I'm going to ask the county clerk if proper notice has been provided pursuant to Idaho statute.
Yes, it has.
And I want to verify that the appellant and their representative are present
Yes.
and that they filed the original bill and also received notice of this hearing.
Yes.
Thank you. Have the county commissioners, whom you all probably know, introduce themselves just so that we know who the players are.
Commissioner Blair Dance.
Commissioner Mark Chandler.
Commissioner Rick Keel.
As we proceed now with this public hearing, I must first make an inquiry of the Board of County Commissioners. Do any of you have a conflict of interest in your ability to hear in an impartial fashion this matter?
I have none.
I do not. Have any of the commissioners viewed this subject property outside of any official site visit?
I have not.
No.
Oh.
Finally, have there been any ex parte communications? And by that, has any member had an ex parte communication with the applicant or the appellant?
I have not.
None.
None.
Have any of you had an ex parte communication with a representative of the applicant or appellant?
I have not.
No. And finally, have any of you had ex parte communications with members of the public about the application under consideration?
I have not.
Yeah.
Um,
Want to make the public aware that the county commissioners have in their possession and have had for some period of time now, all of the written comments that have been submitted. And at this time, we will mark as exhibit 1 to this hearing, all of the public comments that have been sent into the county. Both those that were sent in at the time this matter was heard before the Planning and Zoning Commission, as well as all of those comments that have been submitted in advance of this hearing. And as I say that, just make you aware that the commissioners have all that written comment and had the opportunity and have in fact reviewed those written comments. So there really is no need for you to testify and reread your written comment because it would simply provide a duplication in the record. So the procedure that we will follow is that first I will ask the staff to give a staff report on this matter. After the staff report has been provided, then we will turn to the applicant, and the applicant has been allocated a total of 30 minutes for their presentation. They will divide that time because it's like a Supreme Court argument. You get to decide whether you want to take 15 minutes up front and 15 minutes at the end, or 20 minutes up front and 10 minutes at the end, but we are limiting their time to 30 minutes. And so it's my understanding that their initial impression is that they will try to take 20 minutes initially and reserve 10 minutes. It turns out they only take 15, they will have 15 at the end. If they take 25, they'll only have 5 at the end. Just so everyone understands the rules by which we are playing. After the appellant has had the opportunity to make their initial presentation, then I will go to the sign-up sheets and allow for the public comment period of the hearing. And I apologize in advance to the extent I mispronounce any of your names. Part of it will probably be my dyslexia, and part of it may be your handwriting. Whichever the case, I will apologize in advance for any errors, but feel free to correct me. And when you approach, in order to testify, because we're recording these proceedings, you will need to approach the podium and state your name and your address as prior to commencing your testimony, so that we have a clean record. We would encourage you to not engage in any personal attacks by either the appellant or by those supporting or those opposing the decision of the Planning and Zoning Commission. We encourage you to stay focused on the issues that are directly before the Board of County Commissioners, and that is the interpretation of the county planning and zoning ordinance, land use ordinance. So we encourage you to do that. Again, we will not be wanting anyone to be disruptive during those proceedings. I hope we have no need to call on any assistance in that regard, and that everyone will provide an appropriate level of respect for each other. The commissioners are anxious to hear from the people that are here today for this hearing. And so we ask therefore that you allow that to occur in an orderly fashion. Applause are not appropriate, boos are not appropriate. Consider yourself as if you were in a courtroom, and that you would be required to provide that level of decorum. So we thank you in advance for your willingness to do that. At this time, based on the number of people that have signed up, we intend to allocate 4 minutes to each person who wants to testify. If you don't want to take the full 4 minutes, you're not required to, but we will limit your testimony to 4 minutes. And when you get down to 1 minute, I'll probably try to signal you like something like this to let you know that you're getting towards the end of your time. And then after all the public have had an opportunity to testify, and that is completed, then, as is always the case in these types of quasi judicial proceedings, the appellant, whatever time they have reserved, whether that's 15 minutes, 10 minutes, or 5 minutes, they will have the opportunity for the last word, for what we refer to as rebuttal. And at that time, the hearing will be adjourned. Just so that you're aware, the commissioners are not likely to make a decision tonight on these proceedings. Rather, the fashion that the commission operates under is that they will take the matter under advisement, and then within 60 days make a decision based on the testimony and their interpretation of the Land Use Planning Act, the Idaho, the Fremont County ordinance that governs this matter and the evidence that's provided in this proceeding today. So with that, we will go ahead and ask Tom Buff on behalf of the county to provide us with the staff report, and he also is time limited. His time limit on staff report is 15 minutes.
Okay. You have a staff report.
Just before you start, let me just mention, the county commissioners do have the right to ask questions at any time during these proceedings, either on the during the staff report, the appellant's presentation, or any of you during your testimony. So there is that possibility that you may be asked a question. Forgot to mention that, so don't want anyone to be surprised as a result. Thank you, Tom. Go ahead.
You have a binder that has a staff report and a number of documents that are referred to in the staff report. If you go to page 1, it's an introduction that shows you the location and identifies some basic facts relating to the application. Page 2 is a table of contents. It outlines how the staff report is organized and identifies the documents including the staff report. There's this staff report labeled as tab 1, appeal report. There's Ensign Hospitality's appeal, that's tab 2. Their appeal includes some documents that are in other tabs and it explains that. Tab 3 are written comments submitted for this hearing. Well, for the hearing that was canceled in June. You also have been given copies of the hearing of the comments that were submitted for this hearing. Tab 4 is the decision P&Z made and their findings of fact documenting that decision. Tab 5 is the minutes of the public hearing on November 9th, when P&Z heard this matter. Tab 6 is the staff report for that hearing. It has some attachments that are explained there. Tab 7, which is not in your binder, but there's a copy of that on the table there, contains the comments received for that hearing on November 9th. The next page it explains what happened before this hearing. Standards of review identify some of the rules you may need to refer to as you deliberate over this and decide. You go to page 6 as a summary and analysis of P&Z's decision. A brief synopsis of this is, as they deliberated, P&Z were concerned about compatibility of Ensign's project with surrounding land uses, impacts on wildlife, and the definition of guest lodge. They then denied Ensign's application, and there's some explanation of that on page 6, section B there under item 1 explains that. Also tab 4 has their findings that explains it in greater detail. Turn the page to 7 as a summary and analysis of Ensign's appeal. It summarizes what they said in their appeal document. I'm not going to go through that because they're here to give their own account of it. The 2 main points they raised: they argued that P&Z was wrong about the guest lodge, and they asked their class 2 application be approved. Bottom of page 8, there's a summary and analysis of comments received. There are many pages of comments, both for Ensign's appeal and for their class 2 application. This section offers some analysis of those. I'm not going to go through it. But you should take the time to understand the various points raised in those comments so you can discuss them when you deliberate. The next section on page 10 is additional analysis. This focuses on the key issue of this appeal, which is, what is the definition of guest lodge and what is the difference between a guest lodge and a hotel? This section summarizes the definition that I came up with when the applicant asked if they could do this use. summarizes P and Z's definition that they came up with when they made their decision to deny the application, summarizes the definition offered by Ensign, and also points to some of the alternative definitions offered in the written comments, where the reason given for the definition are more substantive than mere opinion or conclusory statements. And then the last part here is what's next. And you take testimony today from Ensign and from the public, review the statements given today and the written comments and the information on the record. Then you discuss this and with amongst yourselves and with your legal counsel and decide. The key issue is what is a guest lodge? And then you direct staff to write a written explanation of your decision that describes why you decided that way and what facts and record support your decision. The findings of fact and conclusion of law you'll prove after you make your decision. All right, then there's an addendum. This is an explanation that we originally prepared for P&Z training that outlines how counties are supposed to make decisions as envisioned by LUPA and also interpreted by the courts. As you sift through all of the information you've been given, this might help you sort out which items you need to note in order to make a good decision. That's all I have for my presentation. The staff report explains all of these in more detail and you can review it at your leisure. Do you have questions for me?
Commissioners, any questions for staff? No.
Okay.
Thank you, Tom. We're off to a good start. You can see it looks like we got that done in 1/3 the amount of time. It was a lot. Now we'll go ahead and request the appellant, Ensign Hospitality, make their presentation, and I understand that Jared Nelson will be making that presentation on their behalf. So if you'll approach and sign and provide your name and address.
Thank you. Good to be in front of you today. My name is Jared Nelson. I'm with the law firm Dorsey & Whitney, BOCC, Idaho. I like to say Ensign Hospitality. Law firm address is 101 South Capitol Boulevard, Suite 1100, Boise, Idaho.
Can't hear you. Please speak.
Is this better?
Yes.
Perfect. It's a pleasure to be in front of you today. I'm glad to represent Ensign and present on behalf of Ensign for this appeal. Of course, we're appealing the decision of the Planning and Zoning Commission when it related to, as it relates to the preliminary plat application for the Class 2 permit for the hotel to be built as a guest lodge within the rural base zone. The important points here of the commission's decision that obviously is the subject of the appeal are threefold. One, the commission decided that the proposed development was outside the character of uses in the surrounding area. They also determined that the proposed development would not protect wildlife in the surrounding area. And they also held that the proposed development was not consistent with the public perception of a lodge in Highland Park. I hope to address the reason why we are before you today on those three issues in depth. I think principally the first point I hope to discuss is the definition of guest lodge and how it fits within the rural base zone as a permitted use. And then I hope to also address their concerns or the commission's decision discussing that it was outside the character of uses within the surrounding area and would not protect wildlife. Of course, we're before in an appeal before this honorable board today, and the Fremont County Development Code does allow for this appeal, and we have timely filed this appeal. This board today will review the appeal and make a decision as to its compliance with the code and the comprehensive plan. And then per the Fremont County Development Code, this board should also then determine either to affirm, modify, remand, or reverse this decision accordingly. Of course, we advocate here that the planning zoning commission's decision was incompatible with the Fremont County Development Code, and that their decision should be reversed. So I want to begin with discussing the term guest lodge. Guest lodge is an expressly permitted use within the rural-based zone, which is what the property is zoned for. Guest lodge is listed in the Fremont County Development Code as a commercial use. And I think that's important. When you look at section 10, which is the definition section, guest lodge specifically is not banned. And I think that is what created initially some ambiguity as to what the term guest lodge means within the Fremont County Development Code. As there's no explicit definition, you could find specifically stated guest lodge within the code. Nonetheless, there's enough within the code that we can ascertain what the intent was of the drafters when creating the term guest lodge. If you look at the term lodge as defined in section 10, well, first and foremost, the guest lodge, or what the proposed development here is a hotel. It's synonymous with the definition of hotel within the code. So it's not that Ensign here is trying to hide a hotel behind a guest lodge. This is a hotel. If you look at the definition of hotel in the code, I mean, what Ensign is proposing meets that, right? It's a hotel is a place of business. Typically, staff is available 24 hours, usually clearly commercial in character, includes other associated uses, you know, and a place where guests rent out separate rooms within a larger structure. So yeah, I mean, what we're proposing here is not inconsistent with the definition of hotel. But I think based on the language, as I'll continue to explain in the code, guest lodge is something additional to a hotel. That's why by approving this proposed development as a guest lodge, we're not essentially nullifying the definition of hotel. Something could certainly be a hotel and not a guest lodge. And so I'll continue to explain that. But as we look through the definition section here, you know, guest lodges, and then their lodge is defined as a resort within chapter 10. The resort is defined, it's a broad term that includes more remote recreation uses or destinations such as lodge. So, and then we have a contradiction there because a lodge is a resort, but a resort is also defined as a lodge. A retreat, youth camp, do ranch, and so on. Resorts are typically reviewed and approved as an all-inclusive conditional use permit where all of the buildings, uses, and activities that fall under the umbrella of the resort will be described and linked together. I think it's important to note that the all-inclusive language in that describes the conditional use permit, not a specific service that the resort will provide. It's not like they're an all-inclusive resort. That's an all-inclusive conditional use permit on which will be approved. But I think we find that the definition for resort doesn't really help us because of that circular contradiction defining what guest lodge is. Additionally, lodge is found in Appendix I of the Fremont County Development Code. It defines lodge as a rustic structure typical or reminiscent of the historical look and feel of the area. Structures and offering overnight visitor accommodations. These uses may include facilities available to the general public, including without limitation, meeting, dining facilities, provided they are an integral part of the lodge. I think certainly a hotel fits within that definition. I don't think that's that weeds out a hotel. Certainly a place accommodating overnight guests or overnight visitor accommodations, as this one says. And but the key distinction between this and the hotel definition is the aesthetic, right? A rustic structure, typical or reminiscent of the historical look and feel of the area. A general hotel, which would be in a commercial zone, wouldn't have to maintain that type of aesthetic or that rustic look. It could look as any building it likes, right, within the commercial zone. So therein lies the distinction between what we know as the hotel within the code and this definition here of lodge within Appendix I. I think it's important that Appendix I references home occupations, and particularly guest lodges within the Fremont County Development Code is zoned as in the rural, or is a permissible use in the rural-based zone, and is a commercial use, and it explicitly states not Appendix I. So we know that a guest lodge is not intended to be a home-based occupation. It's not intended to be a bed and breakfast. or somebody running Airbnb out of their home or something of that nature. It's intended to be a commercial use in a commercial building. And I think that's pretty clear as you read the rural-based section of the code. Now, the definition of lodge that we're pulling from does come from that appendix I, which discusses home-based occupations. But it's important to note that that definition is not singular to a home-based lodge. It defines lodge generally. It defines lodge both synonymous with the commercial use and the home-based use, right? It could be both. And so certainly I think the definition does not weed out a commercial use. But it is found within the section referring to home occupations, which we also know the guest lodge isn't. But the reason why the definition of appendix I is important is because as we look to this, the Idaho courts as they interpret ambiguous code, they follow certain rules and certain procedures in interpreting what some term that's ambiguous means. And I think it's important to note too that the courts do this. It's not shoestringing. They don't make up definitions. They consider the code and the laws together to come up with a reasonable and plain meaning of the ambiguous language. One of those rules that the courts will follow is that ordinances which are of the same subject matter are to be taken and construed as one system, and the object it carries into effect the intention. Essentially, the intent is to be consistent and harmonious in its several parts and provisions. So a lodge definition within Appendix I discussing home-based occupations is not intended to be different or mean something else with the rest of the code. Appendix I is part of the code. It's incorporated into the code. It's referenced to the code, and it's not intended to be different than the code itself. And if there is ambiguous language, then the assumption is per the Idaho courts that it's intended to everything work harmoniously and consistently. And I think that's a very important piece as we consider the only shred of that lodge definition that we have, which is in Appendix I. It's meant to be synonymous, consistent, harmonious with the rest of the code. So then leaning on that and understanding that the word guest in front of lodge doesn't change the intent here either. It doesn't turn it into something residential or smaller. Because as you look at the definition in section 10 of guest home, it says see hotel. So clearly the code has defined guest home as a hotel. And so putting guest in front of the term lodge doesn't make it something other than what it is, which is a hotel. And so it's not the guest that then would remove it from being synonymous with a hotel. So in sum, guest lodge, while not explicitly defined in section 10 of the code, is defined pretty clearly as you consider the entirety of the Fremont County Development Code and its intentions. It's a commercial use. It's not intended to be a home base. It's not intended to be a bed and breakfast or an Airbnb. It is a place that accommodates overnight guests and offers other services like dining services or meeting spaces. And particularly, it matches the rustic aesthetic synonymous with the rest of with the historical feel of the area. The proposed development intends and tries to meet that aesthetic. It tries to meet that rustic feel, as shown in the depiction in the application. So the proposed development here, while yes, offers rooms within one building and for overnight guests, it offers dining spaces and meeting spaces just as a hotel would. But its intention is to meet the rustic aesthetic, as the rustic lodge aesthetic, sometimes with the historic feel of the area, which then separates it and moves it from the hotel to the guest lodge. And so we ask that that this board consider our proposed ideas of the definition of guest lodge and recognize that guest lodge and consistent with the administrator's report that guest lodge is indeed permitted use within the rural-based zone, and this proposed development is guest lodge. Additionally, briefly, I want to discuss two other points of the commissioner's decision. One, that this will somehow interfere with the wildlife, it won't protect wildlife in the area. Wildlife has been a concern of Ensign as it's proceeded through the application process, communicating with the Idaho Department of Fish and Game, as noted in the application materials, and also, Mr. Clough as well has communicated with the Idaho Department of Fish and Game as to suggestions to prevent any damage or harm to the wildlife area. Important also to consider is that, the rural-based zone requires has an open space required for a reason. And presumably wildlife is part of that as it desires to maintain its rural nature. And the proposed development meets the open space requirements, which is well beyond 65%. So certainly wildlife is being taken into consideration by the code when requiring that open space requirement in the rural zone. So to say that it won't protect wildlife, I don't think is an accurate statement. And also that provision comes from the comprehensive plan. There's nothing within the rural-based zone requirements that require protection of wildlife. That's a goal based on the comprehensive plan, which, while important, is not codified into the rural-based zone and isn't the basis solely to reject a proposed development. There's Idaho case law that suggests that when a governing body uses the comprehensive plan to deny an otherwise lawful use of land, it essentially from the bench codifies the comprehensive plan to rezone property, and it's not permitted to do that. So that alone is not a basis to deny the application, but certainly it's something that Ensign is willing to continue to coordinate with the counties on and for the protection of wildlife. Next, the surrounding uses. Certainly, the surrounding uses aren't. This proposed development isn't bound by the code to meet the aesthetic or similarities of surrounding uses. There's nothing in the rural-based zone that requires it to match surrounding uses. There's nothing in the class 2 permit that requires it to match surrounding uses. And there's actually quite evidence to the contrary that it does. There are other overnight accommodation places nearby, neighboring parcels. There's a towing operation that would be across the street. There are residential units in the area and hotels within a mile distance from it. So there certainly are other uses in the area, but that's also not a burden that Ensign has to meet. Additionally, when looking at the public perception of what lodge means, that's also not a burden that Ensign has to meet for its application. There's nothing in the code that suggests that Ensign needs to prepare anything that matches what the public perceives needs to be. The code is the code, and Ensign is certainly bound by the code. But there's nothing to suggest that it has to somehow with the expectation of perception of guest lodge. But I think the code is still pretty clear as to what a guest lodge is. As the administrator, Mr. Clough, and I have kind of both explained, it's synonymous with the hotel, but I think it offers that distinct feature of its aesthetics. And so certainly that wasn't a requirement that Ensign had to meet, was the public perception. I think finally the principal point here is that this is a permitted use within the zone. Ensign is not attempting to rezone the land, is not attempting to make it something that it's not. It is a permitted use within the rural-based zone. Guest lodge is a permitted use. There is no conservation restriction over the land. There's no additional county overlay that would prevent this. This is a permitted use within the zone. And certainly as to development standards and other updates that need to be a part of it, certainly the Ensign is going to work with the county to meet the county's expectations on what this is to offer to the county. But as far as denying it, the use in its entirety, just because it's not perceived by the public to be a permitted use within the zone, it's not a valid basis to deny this application. It's a permitted use within the zone. This proposed development is the guest lodge. And we humbly request that you reverse the planning and zoning commission's decision and rule that this proposed development is and the guest lodge is permitted for all this. I'll reserve the rest of my time for afterward.
Other questions from the commission?
I have a question. In your written material, you make the statement, the plain meaning of guest lodge includes a hotel type structure in operation. Can you explain what you mean by plain meaning?
Plain meaning is a term often used in the Idaho courts to define ambiguous code. Courts will typically look at the plain meaning of the words. And so that is a judicial term typically used. I think in here, what I meant by that is based off of the comprehensive review of the Fremont County Development Code. I think it's pretty plain what guest lodges to mean, considering, you know, it's a commercial use, it's not a home-based use, it's not a small, a bed and breakfast or something like that. And considering that the definition of lodge is what it is in thing inside, which is clearly intended to be synonymous throughout the entire code. I think when you're looking at those contexts together, the plain meaning of a guest lodge is to be a hotel with obviously the caveat of its appearance and aesthetics and things of that nature. So hope that answers your question.
Any other questions from the commission? No. I should show that you've used 18 minutes of your time.
Great.
Certainly less.
Great, thank you.
Now, we will now open the hearing for public. Now open the hearing for public comment. Before we start with public comment, I just want to remind you that the purpose of public comment is to do just that, provide public comment. It's not to answer questions about the applications or make other ask questions of the applicant or commissioners. Provide your public comment on this application and on this appeal. Remind you that all statements given should address the merits of the proposed application as measured by compliance and lack of compliance with the Fremont County Development Code. And statements that don't address those merits are not appropriate. So what I'm going to do at this point is I will call up the first name and I will also indicate who the second person is going to be so that they can be prepared. And that person ends, second person is just before the second person starts. I'll try to let you know who the third person is going to be and proceed accordingly. As I've indicated, you'll each have 4 minutes. Sir, you have questions?
Yes, if we have 4 minutes and use it all, you borrow 4 minutes from another person who's already signed up. This has been custom in all the series.
No. Each person will be responsible for their own public comments that are signed up. Each person is allocated. Okay. So when we start, we will start with Richard Voss, who will be followed by Marley Voss.
I'm Dr. Richard Wallace. I'm the president of the Lake Osage HOA. Address is 3561 Rock Creek Lane, Mark, Idaho 83429. Thank you for giving me this opportunity. I would like to kind of challenge something that I heard just a few moments ago about not being required to protect wildlife. And if you look at 4.13.010 under objectives, the very first one, and I'm not going to read the whole thing, but it says, to protect fish, wildlife, and recreational resources consistent with the purposes of the local land and land use planning act. That is something that is part of what they need to do. There's a number of things that need to be, I think, fully defined. One, I did a lot of research on the whole idea of guest lodge versus a hotel and went to several websites. I would refer to a site by all of them called Legal Insider. I'd like to read their definition. Their definition of a guest lodge is an accommodation typically located in a rural or scenic area that provides lodging and meals for travelers. It is often smaller and more intimate than a hotel, sometimes resembling a large house or cabin, may be run by individuals or families. Guest lodges may vary in style and amenities ranging in basic to luxury. However, they generally are from seven or more, but no more than 20 rooms. They do not provide a lot of services. The proposed plan here is, I would contend, not a hotel, but a complex, because it's not only a hotel, but housing for 25 employees, I believe it was 3 guest homes that they wanted, 3 houses or 5 houses they wanted to put in, a spa, a restaurant, and a bar. That is not a lodge, that's a complex. Oh, and a convention center also goes along with that. So we need to consider those facts as well, and that's, again, it's not just coming from me. We also if you look at Air DNA, which is a company that follows Airbnbs and VRBOs, there are already over 1,500 Airbnbs and VRBOs in the Island Park area, which only average 57% occupancy. So there's 43% occupancy not used. So we don't need another 132 rooms. You've already got 111 room hotels sitting there. Wastewater. I'm concerned about the water use. Hotels generally, if you read through hotel documents, average 100 gallons of water per guest per day. If we're talking about a hotel as large as 132 rooms, we're looking at 13,200 gallons of wastewater being produced every single day. I don't know how many of you here live in Island Park, but the Island Park wastewater system cannot handle an additional 13,000 gallons. We're having difficulty going through what they're going through right now. Several people in parts of Island Park have had to live on boil water requirements for a long time.
Oh, yeah, 1 minute.
Okay, I'm sorry. Okay. There is for those old enough to remember Star Trek, there is something that comes in. It says the needs of many far outweigh the needs of the few or the one. In this case, the needs of the many are what need to be considered. Everything I've given you is not opinion, is not conjecture, it's hard, documented fact, which you can look up. I can give you the references if you need it, but I think this thing needs to be denied. There's no good reason for putting it there. A guest lodge is a guest lodge, but this is a complex. This is a hotel. This does not meet the definition of a comprehensive plan. Thank you.
Any question from the commission?
I have one,
Sure.
your reference to boiled water in Island Park was due to private systems, okay, that failed. Right.
Understood, but it still affected all the residents, and at our last hearing, we were told very distinctly that the current wastewater system in Island Park could not sustain another 132 or 30,000 gallons. Pardon?
Water from a source, and you referenced that was water from a source.
Well, this was water in the Island Park sewer system. And water is coming out of those homes that are on the sewer system now, or right now overwhelming it. We're talking about a hotel going on, and unless they're going to put in a septic system of their own. And that's not anything that we've heard from in all the meetings that I've attended. Okay, you're talking about linking to the Island Park sewer system. They link to that sewer system, you're putting 13,000 gallons a day into that system. They cannot.
Thank you.
Are there any other questions? Now I hear from Marlene Haas, followed by Angie Dillon.
I was going to defer it again, but keep having one.
Thank you.
Thank you.
Angie Dillon, be followed by Anthony.
Angela Elam, 3524 Gold Moose, Island Park, Idaho, 83429. First off, thank you commissioners for allowing the public to speak on this matter. I'm going to give you a little bit about the background. I have 35 years of hospitality experience. I have managed hotel, I have managed resorts, I have managed guest lodges. In the world of hospitality, there are two different definitions of a hotel and a guest lodge. A hotel is anything larger than 20 rooms and typically larger than 15 bathrooms. That is well known throughout the hospitality industry. A guest lodge is anything smaller than 20 rooms and usually less than 15 bathrooms. Interestingly enough, the largest guest lodge in the US is Timber Lodge in Colorado. It is 26,000 square feet and only has 13 rooms and 17 bathrooms. It does not have employee housing. It does not have a spa. It does not have a restaurant. That is the definition of a guest lodge. Nothing has changed since the planning commission correctly denied the application based on solid evidence and the use of the development code and comprehensive plan. When the planning development receives a development application in any jurisdiction, the first thing they need to do is look and make sure that it fits within the zoning. If you view the rural base zone for allowed usage, you will see that nowhere does a hotel appear as an allowed use. A guest lodge is listed, but is not defined in the development code at all, and there is no use within the development code called guest lodge or hotel, which is what was published. That would make the publication inaccurate, and it should never have been heard as published. According to the Fremont County Development Code, there is no confusion on this matter. Section 4.05 states, if a proposed use of property is not specifically listed in Chapter 4, Division 2, base district regulations, the use shall be prohibited. The code goes on to say, to allow for administrators to determine if a requested use that is not specifically listed is equivalent to an allowed use, it may then be allowed. This does not apply to this application because the use of guest lodge and hotel are already specifically listed. The publication incorrectly added a new use, which is guest lodge / hotel, by combining two separate uses which are both individually and specifically listed in Chapter 4, Division 2, base district regulations in the development code under different zones. Nowhere on the application was a guest lodge mentioned. The developer's application states, and I quote, "We are proposing to build a resort hotel, residences, and employee housing in an area commonly known as the Flats in Island Park in Fremont County." End quote. In the plans but not included in the statement are a restaurant, bar, and spa. The planning commission was asked to determine whether a resort hotel is the same as a guest lodge, so as to allow it in the rural base zone. The request is not just for a hotel, it's for a resort hotel. This is again an attempt to sidestep the development code language. A guest lodge is allowed in the rural base, rural conservation, rural living, and residential rural urban transition zones. In the residential rural urban transition zones, the categories of motel, hotel, and guest lodge are listed separately as allowed uses. It should be clear that the intent by the authors of the development code was that a guest lodge is not the same as a motel and hotel, as testimony in the previous hearing denying the application pointed out. In the commercial zones, a motel hotel is allowed beginning in the commercial limited office zone, commercial neighborhood zone, and only then by conditional use permit. Hotels, motels are not allowed without a conditional use permit until the commercial community zone and the commercial regional zone. Zones that allow a development with intensity of this resort hotel are located outside of rural zones. Considering that Island Park is zoned with a rural destination throughout the area, a decision that a guest lodge is the same as a hotel motel would provide for development or throughout Island Park and the balance of Fremont County in a rural zone. It is a precedent that should never be set.
Thank you. Any questions, Commissioner?
I have them.
Now I hear from Anthony, followed by Robert Phillip.
I'm gonna pass.
And Anthony passes.
And my wife pretty much said what I had to say. So,
Okay, and Robert Phillip has passed. Pat Ridley, followed by Kay Ridley.
Pass it with the top.
Right.
Oh, pass.
Pat really passed. Pat and Kay both passed. Thank you. Jan Brown. And she will be followed by Elaine Weingarten.
Tom, I have this in writing.
Is that- Hope that's it.
Would like to get them.
Elaine. Wine. Yes, finally. Thank you. Apologize.
I want it to be able to.
You made it. Wow. I understand, Ms. Brown, what you're asking, you handed the commissioners your written comments and we're asking that they be attached as and made part of the record.
Because they're more than.
Thank you. And with that request, it shall be attached.
Thank you. My name's Candace Brown. I have a cabin in Island Park at 3508 North Pine Lake Drive, but my residence is actually 1870 St. Clair Road in Idaho Falls. 404.
Needs to be credited to that.
Okay. I'm pleased to offer my comments on this action. As both the prior owner of a true guest lodge called Lucky Dog Creek in the 1980s, as well as a nonprofit executive who was a year-round resident in Island Park from 1982 to 2000. I was a member of the original Island Park Land Use Advisory Committee that created, that was appointed to help consulting planner Lee Dallas create the Fremont County Comprehensive Plan and Development Code between 1990 and 92. So I was one who knew the original intent of the language. I'm going to skip the next two paragraphs. That's background on how we developed that code and the award that Fremont County's Plan and Code won from the Western Planning Associates for its outstanding nature. Unfortunately, much of the plan was changed because of it. It was felt to be too subjective, but I do believe that now the larger code is now equally subjective. Following adoption of the Fremont County Plan and Code in 1993, I was asked to serve as one of the original members of the City of Island Park's Planning and Zoning Commission. We began work on an appropriate plan and code for the city's jurisdiction, and we emphasized policies that addressed commercial development. In 1996, the commissions of both the city and the county jointly published the Island Park Guide to Commercial Development, a document that may be out of print, but it does address what we had as commercial nodes and commercial areas to prevent strip development up and down Highway 20. We also had design guidelines for commercial development, and we specifically wanted to aid those who wanted to develop in visually sensitive areas. We referred this to what was referred to as a traditional small-scale resort style of Island Park is well described in that document. It does not resemble a 132-unit hotel, a 5,000 square foot space, restaurant, bar, spa, etc. Under the original code, such a proposal as this would automatically fall under the category of a large-scale development. And as mentioned above, it would have been prohibited from visually sensitive areas, and it would have been prohibited because it's outside the designated commercial nodes. Now, that's the old origin. Now, the issue at hand is whether a guest lodge is equivalent to a motel hotel. Under the current code, guest lodge is not defined as we discussed, but we must search for in the document where the two terms are used equivalently, interchangeably, or perhaps there's a place where they are listed separately. On page 56, under the description of the rural urban transition zone, that's called the RUT, there is a list of commercial uses where you can see that motel hotels are listed separately from a guest lodge. Plainly, these are two different uses. If these were considered to be interchangeable, they would not have appeared on different lines in this list. So I don't think we can assume that these are interchangeable. They are absolutely different uses. Finally, an interesting reference is on page 82 of the current ordinance, where the three planning areas, the original Island Park, North Fremont, and South Fremont planning areas are referred to. And in bold here, I have put down that they are hereby authorized to establish continuity with previous editions of the ordinance. That is a really interesting statement. Because what it says to me.
Your time is expired. Are there any questions from the commission?
My final paragraph you can read. Thank you very much.
No question.
Lane. Weingarten, to be followed by Dan Yancey.
My intention was to keep it very short and put my time to someone else.
You state your name
I'm an A1 for
and your address, please.
3686 Gillsleeve Road.
Thank you. Please proceed.
First thing I want to say is I'm adamant of any emergency on the flats. It needs to be pristine. The commercial developments that are there now have been there for many years. The record place that you talked about was originally Hungry Bear, and it was on a conditional use permit. And I don't know how he got the record. All the stuff there. Yeah. We had Valley View rental or the RV park and the gas station that had been there for many years before we bought it. There are commercial nodes, like she mentioned, should have been adhered. I am upset with the commissioners because you make all these people drive down the hill when 10 of you could have given up to them instead of all of us. And there would have been a much larger attendance. People weren't afraid of driving back up the boulevard. Anyway. This is a hotel complex, like she said. It is not a lodge by any means. It's just not. And the other thing that I was concerned about is two things. You say it's rural based zoning. But on the last page here, or the addendum page, it calls it RCP, which is rural conservation, which is it. And it's not commercial. I don't understand it. It's been Island Park City United. You guys have denied it. You've allowed them to come back 3 times, I think. But can't think of the word right now. Anyway. Ask again to have the same talked about. I don't know why some of you other people like that. I didn't say anything. I was hoping that people from Michigan and places would be here again, because they know a lot more about this stuff than I do, other than I know that the aquifers and the animals, habitats, everything just needs to be left alone. I don't want to be another Park City or defunct. Can't think. I'm so upset. I think that we need to think seriously about what we're doing here. Because that is definitely not a lodge on anything. It is a hotel complex or resort or both. And we can't have it. We can't have it. Thank you.
Thank you. Nan Yancy, followed by Terry Ishman.
Who wants to ask questions on it?
Oh. Are there any questions? Question?
Sorry. No, okay.
I apologize.
Sorry.
Leanne Nancy, 753 North, 3100 East Chester, 5174 Shauna, Island Park. Thank you. I wish to address these critical points. Fremont County Development Code Division 8, 5.51 large scale development. Defined for the purpose of this application is a residential or commercial mixed use project or a series of adjacent or related residential or commercial mixed use projects that will contain more than 15,000 square feet of commercial space. The Ensign application proposed a 132 room, 3-story resort hotel with 5,000 square feet of meeting space, a kitchen, restaurant, bar, bistro, large commons area, spa, store shop, stairs and elevators, multiple covered outdoor patios, including a wedding patio, a pool, and in addition, 10 rental residences, landscaping, parking space, roads, and 25 employee housing. The scale, scope, and detail of the proposed application far exceeds the 15,000 square foot threshold. Mr. Barker confirmed this fact at the Island Park hearing. This is a large scale development application, but it was not processed as such. In addition, the Henry's Lake Flat is zoned rural base, and rural base zoning does not intend large-scale commercial development. County code and zoning directs all development of this type and scale to the city jurisdictions and away from rural base. The appeal letter states, the principle of this appeal is based on the definition of guest lodge. Ensign did not define its proposed project as a guest lodge in their application. At the P&Z hearing in Island Park, Mr. Barker called this project a hotel at least 3 times. The term guest lodge was introduced after the hotel application was submitted. When? The administrator report states that the administrator's reading of the code and choice to further process this application based upon his determination that the terms hotel and guest lodge are synonymous, and I quote, regardless of what the individual, even if that individual is the applicant of this project, the proposed use fits in the category of a guest lodge. Fremont County Code does not have a category or a definition of guest lodge in our code. The appeal letter contends that the commission erred when it failed to define guest lodge and when it held that the development was not a lodge. How could the P&Z fail to define a guest lodge when the Fremont County Development Code is silent on that term? Therefore, the P&Z did not err or fail to define a project term that is not in our code. Please note that Ensign in this appeal is using the Fremont County definition of a hotel. It is Ensign who failed to define their own project as a guest lodge, if that is what they intended. Quote, Mr. Barker, we are proposing to build a resort hotel, residence, and employee housing in an area commonly known as the Flats in Island Park and Fremont County. I wish to preserve for this hearing record a request for, should this application go further, an independent and expert review of the county record in the processing of this application and the late changes that were introduced. The new terminology acted to amend the original application, impacted its consideration by the P&Z, and is now being used as a principle for this appeal and the claim error by Ensign. In closing, the P&Z rightfully denied this application based on code and policy, determined it was a hotel and not a guest lodge, and that it was a large-scale development, not appropriate for the rural-based zone of the Henry's Lake Flat. I urge you to uphold their decision and reject the principle and error arguments of this appeal. Thank you. I stand for question.
Are there any questions from the commission?
I have none.
Thank you. Terry, followed by Dave Bloxam.
Terry Ersman, 304 Lariat Road, Island Park. Commissioners, if in fact the developer is to be held to the same standards of other developers of motels, hotels, this application is entirely out of place. The request for a Class 2 permit, by being allowed to request a Class 2 permit instead of the required conditional use permits for hotels within commercial zones, you are being asked to allow less restrictions for development in the rural zones, which are designated as ag and low impact development. This and other developments in this intent should not be considered in any rural zones in Island Park, let alone the sensitive areas we know as the Flats. Since a conditional use permit is required in the first commercial zones allowing motels and hotels, it would be inconsistent to assume that a simple Class 2 permit, as described in 3.14.20, would be sufficient in the rural base zone. The ability to regulate a Class 2 permit versus a conditional use permit as required in the commercial zones is significantly different. The conditional use permit allows for more stringent regulations and protections, considerations of adverse effects, and more as allowed by the state statutes specific to the uses allowed in the conditional use permit. On July 10th, 2024, the county civil attorney was sent a letter explaining the concern that a hotel was not an allowed use in the rural-based zone as a Class 2 permit. Despite that, the hearing was scheduled knowing this conflict. It's interesting that on July the 17th, 2024, 7 days after that letter was sent to Fremont County, the developer sent an email to the planning administrator that they were changing the name of the hotel from the Flat Rock Hotel to the Flat Rock Lodge. It appears that the developer is aware of this conflict and supports this attempt to reclassify the resort hotel as a guest lodge. The name change doesn't change the development to a guest lodge. Staff and the developers had nearly 90 days to correct this request, so it would have been appropriate and not a bait and switch. Had they failed to attempt to make us believe a resort hotel is actually a guest lodge. A correct request would have been for a comprehensive map change, a rezone to the appropriate commercial zone, and if approved, then processed under chapter 5 as the large-scale development it is. Large-scale developments are also not allowed to use rural-based zone, as far as restaurants. Idaho statute 67-6535 addresses the approval or denial of any application permitted. The statute states the approval or denial of any application required or authorized pursuant to this chapter shall be based on standards and criteria which shall be set before the comprehensive plan, zoning ordinance, and other appropriate ordinances or regulations of the city or the county. The statute requires that this development be in compliance with the development code and the comprehensive plan. This application does not comply with the development code or the comprehensive plan. This application was in fact denied appropriately and with valid reasons. I ask you that you uphold the denial and support the work of the Planning and Zoning Commission and deny this request. I'd like to add one other thing, that you need to get to work on the comprehensive plan and development code. Thank you.
Thank you, just a moment. Any questions from the commission? Thank you. Dave Watson, followed by John Bowden. Okay.
Hey, Watson, 4536 Cobblestone Road, Idaho. I urge you to deny this based on a lot of what's already been said. This is, number one, it does not fit the comprehensive plan. And this is a large scale project. Your own P&Z board denied it. And I don't see any reason, no new information. You guys have the same information they did, they denied it. I don't see any reason to change that decision. And so I'm hoping that you as Fremont County commissioners will feel your responsibility to all the constituents in Fremont County. That people up in Island Park do deserve representation and to be heard. And not just Fremont County's cash cow. So I would urge you to reject this and assume your responsibilities as commissioners and be transparent. Thank you.
Thank you.
Any questions?
Any questions from the commission? John Bodine, followed by Sally Heischerman.
John Bodine, 4760 Caribou in Island Park. I think that the proposal being brought forward here by Ensign Hospitality is very disingenuous and dishonest. The logic being used here, and I was at the meeting the last time they were told no. They proposed it, they said it was a resort hotel. That's what they called it. And when they were confronted with the facts that it doesn't meet code, and it doesn't say that in code, oh, well, then we'll call it a law. Using that kind of logic might make sense to somebody with an IQ under 20. But for anybody with an IQ above that, there just does not make sense. And I'm gonna go ahead and read part of the the Food Buff's standard of review. On page 4, paragraph C, counties entitled to interpret their own ordinance. Other people's preferred interpretation do not bind the county. Just because someone thinks our ordinance means one thing, doesn't mean the county has to go along with that. As long as the reasons the county gives for how it interprets our ordinances are not arbitrary or capricious, then our rules mean what we say they mean. So, put that in a nutshell, doesn't matter what the ordinances say, doesn't matter what laws say, we'll decide what they mean. And to me, that's very insulting to the residents in Island Park. Using that kind of logic, it's almost like woke terminology. Oh, well, we've decided that we identify as a lodge now. Nothing else has changed except what they want to call it. Well, using this logic, I should be able to identify my property in Island Park as a bare lot and pay taxes based on that. I mean, that's where we're getting down to. It's almost to the stupid level. They were told no, they know it doesn't fit. The development code says it doesn't fit. It doesn't fit. And I would strongly encourage the commission. I know you can tell by the number of people that took the time to drive down here. The residents of Island Park are taxpayers. You, the commission, represents the taxpayers, and we're certainly part of taxpaying people that you should represent. You can tell nobody's for it, and nobody wants it. It shouldn't be done. And I think the folks in Island Park are getting tired of being treated like the ugly stepchild and being ignored. And we really shouldn't even be here. If this is what Ensign Hospitality can come up with, is we're just going to decide to call it something else. I think it's insulting to everybody in here. I strongly encourage you to tell them no. Thank you.
Thank you. Other questions from the commission?
Your name, sir? Yes, sir. Your name, please.
John Bodie.
Thanks, John.
Or no other questions? Next, Sally Heiserman, to be followed by Ryan Arms. The last name correct. ARMES.
My name is Sally Heiserman. Yes, my name is Sally Heiserman. I have an at Springs, 4458 Big Springs Road, in Island Park. I am the 5th generation. You have that habit, so you can't hear that. I'm the 5th generation. You have that. I'm also an attorney, and I know how to code. I spend a lot of time reading code. It's part of my job. And when a code lists allowable uses, those are the allowable uses. Anything that's not listed as an allowable use is not allowed. The distinction in the Fremont County Code that says that there are guest lodges allowed in rural-based zoning is very clear in that it doesn't say hotels are allowed, and hotels are allowed in zoning. So it, just by the plain reading of the code, this complex would not be allowed. When there is a discrepancy in, or ambiguity involved, then you look to the objective code. In section 4.13 for the rural district rural-based zone, the objectives clearly state that they are to conserve and enhance the cultural significance and character of open, rural, and scenic non-urban landscapes, provide agricultural and rangeland uses consistent with the conservation of the environmental landscape, values of the area, to allow development, agricultural, and all of this not keeping with a multi-building, multi-room hotel complex, convention center, spa, restaurant.
The other thing that protecting of the enhancement of the wildlife situation there. Long-billed curlews, sandhill cranes, all mate and produce there. We have one of the larger breeding populations, of long-billed curlews in that area. Once you open the door to something like this, it starts a snowball effect. And eventually it will cause more people to come in and want to build their hotel across the way or their airfield across the way. Leaving a situation where we can't get that back. That's my opinion. Both the plain language of the code, the objections of the code, the enhancement of the wildlife situation affected by this, is just something that can't be allowed.
Questions from the commission? Thank you. Brian Arms, followed by Matthew Igley.
Sir, my points have been made. I work with my time.
Okay, thank you. Matthew Igley, followed by Nelson Ichijama. Close enough? Close enough. Thank you, I apologize.
Chip. Yeah, Matt Hiley, 801 Main Street, Ashton, speaking on behalf of the Henry Ford Foundation, not as an individual tonight. Although if I can speak as both an individual and the staff of the foundation, I would like to do so. What I mean is, would I be allotted more time?
No.
Okay. I'll just speak on behalf of the foundation. Kind of similar to what Rob Van Kirk and I came and discussed to you all about a few months ago. Our concern is kind of falling into line with water supply, water quality. But let me just start, first on behalf of the foundation, thank you for the opportunity to comment. Our mission is to conserve the world-class trout fishery in Henry's Fork and connected watersheds. And to achieve that mission, we work as a science-based collaborator with private and public entities. And then sometimes we engage in land use matters when proposed developments have the potential to affect water supply, water quality, access, ecological integrity and function. And so, speaking to you tonight, we urge you to support the decision made by the Planning and Zoning Commission. That interpretation that guest lodge is different and distinct from hotel. And therefore, this application is not allowed in the rural-based zone. So to not be too redundant here, I'll just skip on to treating the two as interchangeable would effectively allow hotels in every rural zone in the county, eroding the protections intended by both the comp plan and the development code, and potentially creating more long-term impacts to infrastructure capacity, water supply, water quality. From that water resources standpoint, recent peer-reviewed research that was conducted in partnership with the Henry Ford Foundation found that mean annual runoff efficiency is in decline. If we look at the last 20 years compared to the 20 years prior to 2000, it's 15% less. We're working with 15% less water on a basin scale than we were prior to 2000. In other words, sorry, I said runoff efficiency. So in other words, the amount of precipitation that falls, how much that translates to stream flow has declined. And then in parallel, our long-term water quality monitoring program, which is now in its 12th year, has documented a doubling of concentration of phosphorus, a nutrient of concern. And it's a nutrient of concern in this particular setting because in this part of the watershed, where the flats are, the upper watershed, if you will, those declines are even more staggering. They're 22% less than the watershed as a whole at that 15%. And then the presence of Island Park Reservoir kind of makes things more consequential. The reservoir is kind of a center point for the ecological health, the recreational potential of the river, both upstream and downstream of it. You can go out in the river, right now below Island Park Dam, and you can kind of see the effects that algae can have on the river system. And so those algal blooms, whether they're harmful or non-harmful, can affect, can alter the habitat quality, and diminish recreational value. And then these large scale type developments in this setting, could further exacerbate these pressures that we've seen. So we urge you to support the P&Z decision, and if not, we recommend that this application go into large scale development, additional use permit, so that the most appropriate consideration can be met in terms of water,
Thank you.
high water quality.
Any questions?
So these water problems, aren't they pretty Intermountain West wide?
Sure, yeah, it's definitely not unique, although I will say that this watershed is unique in that pool of Intermountain West location.
Thank you. Nelson. Be followed by, I believe it's Justin Bernard. Lives on an island park on well.
I'm Nelson Nishiyama, 2790 South Pine Haven Drive, Island Park. And I own a fishing lodge in Island Park. I have for 35 years. Also been the president of a company that had 300 to 300 room hotels in Australia and New Zealand. So I think I know the difference between a lodge and a hotel. So I think it's very clear from the law, from development code, that a hotel motel is not allowed in the rural-based zone. The rural-based zone is the most restrictive in the rural district. It allows as commercial uses, bed and breakfast, cabin rentals, and guest lodge. The second most restrictive zone is the rural conservation zone. Again, it allows bed and breakfast, cabin rental, and guest lodge. The third most restrictive is rural living, same scheme. Bed and breakfast, cabin rental, and guest lodge, no motel and hotel. But once you get to the fourth most restrictive, which is called the rural urban transition zone, the commercial uses that are allowed, again, B&B, cabin rental, guest lodge, and for the first time, hotel, motel, specifically. So by excluding hotel, motel from the previous three zones, but including it only in this fourth most restricted zones, it's clear the drafters of the development code distinguished between motel, hotel, and a guest lodge. No question about it. And the Ensign appeal hinges entirely on calling a hotel, motel a guest lodge. And that's simply wrong according to the development code. Crystal clear, you have no choice but to deny this appeal from the 6-1 decision of the Planning and Zoning Commission. So, as I said, the difference in impact of a lodge, which is included with the planning, there was the B&B and the cabin rental, is those enterprises are small scale, low impact, low staff. On the other hand, a full-on 132 room hotel has huge requirements for transportation, taxis, vans, tour buses, rental cars, private cars, hundreds of them. And it has also difference in the staffing. They're gonna need maids, bellmen, managers, cooks, hostesses, bartenders, not anything resembling the guest lodge. Those don't have any. Contrast their proposal with my lodge. We have no bar. We have no staff housing. We have 14 rooms, not 132. We don't have 24-hour staff. We don't have staff housing. And we don't have separate houses or separate homes. So it's a completely different animal. And they're trying to disguise it. Disguise a hotel as a lodge. And the planning and zoning code is completely clear. And in addition to that, the comprehensive plan, your predecessors in 2019 directed you to apply the principles of the comprehensive plan. Please do.
Thank you. Other questions from the commission? Justin Bernard, followed by Randy Lehman.
My name is Justin Bernard. My address is 4050 Flat Rock Club Road in Island Park, Idaho. I represent Flat Rock Club, my family. I'm speaking in opposition of the proposed resort. I'm going to start with some common definitions. Resort, a large facility that serves as a destination and includes permanent residences for employees, offering accommodations plus a wide range of on-site recreational amenities and services such as dining, entertainment, sports, or spa facilities, or floating big springs in this case. A guest lodge, a small-scale lodging establishment, often 7 to 20 rooms, designed for transient guests, typically in a rural or scenic setting with limited services and minimal impact on the surrounding environment. This project is being presented under the label of a guest lodge, but by any reasonable or commonly accepted definition, it is not a guest lodge. Constructing a resort in a scenic location does not give the developer the right to call it a guest lodge. Across Idaho in similar rural resort areas, a guest lodge is typically defined by the definition I used earlier. The term guest lodge is being misused blatantly only to comply with the zoning ordinance. In reality, a development comprising of 132 resort rooms, 10 single-family dwellings, and 25 employee housing units is no way a guest lodge. You can always put lipstick on a pig, but a pig is still a pig. A development of this type belongs in a commercial area that is already zoned for commercial development. The mass amount of rooms and inclusion of permanent residences for staff housing moves this entirely out of the category of guest lodge and firmly into the realm of a large-scale resort. If we are here debating definitions, because the developer and some county employees are exploiting Fremont County's lack of a precise one, using that gap against commissioners and the public. And let's be clear, calling this a guest lodge is not an innocent mistake. It is a deliberate misrepresentation designed to sidestep a higher level of review and restrictions that would rightfully apply to a resort of this size. Guest lodge provisions exist to allow limited, low-impact lodging in sensitive areas like Henry's Lake Flats, preserving the rural character and natural resources. Approving this massive resort under the guest lodge label would not only undermine the intent of our zoning ordinances and comprehensive plan, it would set a dangerous precedent for the unchecked commercial development in our most protected areas. I urge you to call this project what it truly is, a resort, and hold it to the standards and scrutiny a massive development like this truly deserves. Anything less is a disservice to the county, its citizens, and the future of Island Park. I want to thank the folks in attendance who legitimately care about Island Park and understand the culture of our area.
Any questions? Thank you. Randy Lehman, followed by Suzanne Holbrook. Thank you.
I'm Brandy Lehman. I live at 425 View Avenue, St. Anthony, Idaho. However, I've been a Fremont County resident for a long time and I absolutely love Island Park. I travel there nearly every other weekend for my own entertainment. One of the things that I heard mentioned that I would like to bring attention to, I don't know if this has necessarily been studied, but I think all of the residents of Fremont County who've traveled to and from Island Park recognize that that is the most dangerous area of Highway 20. We have commonly in summertime and in winter time, because they're both destinations during that time, fatalities. We have accidents that include animals. We have accidents that include people who are unaccustomed to driving in certain weather conditions. We have people from out of town that don't know the dangers that are existing. They have taken measures to open up some of the highway spaces for visibility of the wildlife that can cause such devastating effects. But it doesn't take away the word accident from accident. This is something that would increase that trouble and is a very big concern of mine. I question the things that have been mentioned, the sanitation plan, the water treatment and water reclamation plans, traffic revisions. We, know that it's dangerous territory sometimes. Law enforcement considerations, fire prevention and safety. We're in a hot zone right now. We have fire restrictions. People coming from elsewhere may not know how dangerous it is to have an open flame. Emergency medical transportation and care. Now, the residents' availability for employee and family would also then potentially impact our school districts or our school district. We are not at all prepared for Fremont County School District for an influx of more students. We are already taxed to the seams, class sizes increasing every year. The facilities that we have are not completely adequate now. How do we support more with the potential family coming with the employees? I would also like to address the employee housing. There is a property that is a beautifully maintained property up in Island Park at Max Inn. I recently went into one of those accommodations for employees. One person's responsibility, if they're in a 2-bedroom place, is a $200 a month rental. So one person, $400 a month. Now, my dorm room in college was bigger than this. There were 2 twin beds stuck so closely together. There was no room for additional seating. There was no room for anything. The conditions were actually, I think, original Max Inn employee accommodations. In no way, shape, or form are they to be considered beautiful like the particular hotel that they accommodate. Ensign is here from the concrete jungle, and they have intent to violate the pristine, majestic, and world-class destination for travelers coming to experience just that. The pristine, majestic, natural habitats of animals, of opportunities for adventure, or whether it be snow adventure, whether it be summertime fishing or hiking. But what also needs to be considered is these people coming from out of town or out of area will be utilizing the services of search and rescue. And that is very dangerous. They are stretched thin as well. Please do not allow this property to invade our space.
Thank you. Are there any questions from the commission? No. Thank you very much, Suzanne, and to be followed by Carrie Hanks.
Commissioners, my name is Suzanne Paul. My home is at 5425 Island Park. My permanent residence is 101 Hickory Lane, Bozeman, North Carolina. I only know a small fraction of the people in this room, but I think it's very safe to assume all but a handful of us are here because of one
deeply held belief. And that is that Henry's Lake Flats, its natural environment, its scenic beauty, and its rural heritage are unique and incredibly special. What I heard from Ensign Hospitality's attorney today does not seem to successfully argue that their plans are at all within the current allowed uses. In addition to that, I can think of no benefit to the requested application, even to the human community of Island Park or to Fremont County as a whole. Instead, when I think of the human community, I can only think of impacts. The one that comes to the top of my mind is the increase in pressure on Island Park and Fremont County services. I think specifically of how often the flats are closed in winter due to blowing and drifting snow, sometimes for days at a time. I recall a particular February storm a few years ago when the road past where the current development is proposed. Road was closed for 4 to 5 days. There are a number of stories from this storm of people being stranded and needing aid from local services, local emergency services. At the north end of the flats, near where we have our home, there were half a dozen semi-drivers with their rigs stuck in the road for that whole period of time. I was able to ski down the mile or so from our home to take supplies to the stranded drivers who didn't want to leave their rigs. That was 6 drivers. That was 6 drivers who needed assistance in the storm. What do we do when we have hundreds more out of area guests and the hotel staff complex needing to be cared for in a storm? Does Fremont County and do Island Park currently have, or will they have, the emergency services to respond? My anecdotal story is only one argument against making a decision to change the zoning interpretation to accommodate this proposal. But everything about this proposal seems like a very bad. Please, all commissioners, vote no and send a crystal clear no means no message to these developments. Thank you.
Thank you. Are there any questions from the commission? Thank you. Mary Hanks, followed by Randy Worrell. Randy Hansels. Just a minute here. Cindy Williams would be next. Cindy Williams. Thank you.
Mary Hanks, 463 North, 1800 East. Thank you for this opportunity. I'd like to second the previous speaker on describing the beauty of Island Park. I looked through this handout on page 5 where it talks about guest lodge, and then on page 6, I thought it was really important how it was outlined what the P&Z discussed as the compatibility of the development, those wildlife concerns question, whether it was a guest lodge, which has been talked over and over again. So that's pretty clear. A couple concerns that I have. Approving such a large-scale commercial development without rezoning is really improper. And it just seems like enabling this development without a full revision of the comprehensive plan would undermine the entire planning process. That's a dangerous precedent for the future. There are reasons for the specific zoning. Rural base and other zoning should not be ignored, and it sets a precedent that you may well regret. You can see that happening. And on page 8 in this, it said a petition of over 7,500 signed against this. And so it seems your decision is what's best for our community, what's best for our county and our community. Well, that's, in my humble opinion, what it boils down to. So if you as county commissioners override the P&Z decision without compelling reasons, it sends a message to the
Planning and Zoning Commission that their serious consideration and decisions are not important. At least that's how I would feel if I was on that commission. And they may be reduced to guessing what you as a commission desires the outcome to be. So I am requesting that you support the planning and zoning in this denial and deny the appeal.
Thank you. Are there any questions from the commission?
I have none.
Thank you. Cindy Williams, to be followed by Becky Hall. Becky Masses. Thank you. Barry Phillips will be next. Barry Phillips.
Excuse me, Cindy, just one second. How we do my voice and how much it will. Oh. Yeah, we're just discussing potential for a break.
Yeah, we may need a restroom break for seconds.
Cindy Williams, 4126 South Big Springs Road. Thank you for your time, considering this. Appreciate all the effort that goes into this kind of work. And question.
It's just to give public testimony.
Oh, okay. I've been wondering how many guest lodge properties already exist in our park. And there's probably a number. I don't know what that number is, but I'm thinking just the sheer number of guest lodge properties that already exist have already defined the term guest lodge. They've already established what the common terminology for guest lodge is. So I don't think there's any reason to be entertaining, redefining what's all commonly. So I'm asking to please deny this patient. Thank you.
Thank you. Barry Phillips. Followed by Dee Dee Draper.
Barry Phillips, 420 Howard Creek Drive, Island Park, Idaho, 83429. I've lived there for 23 years. I also served on the city planning and zoning for 5.5 years. So that's just a little bit of my credential. I'd like to bring the attention to you that Ensign Hospitality and the previous owner of the property originally submitted this to the Island Park to have the land annexed into the city of Island Park. And then they also requested a rezoning, which tells me at that time they knew that this was not a proper use of this property without it being rezoned. So now they have said, okay, planning and zoning up there said, no, we're not going to do that. We're not going to partake in that. So what have they done? They've decided, okay, let's call it something else. Let's go to the county. Now we're not going to have a rezoning, but we're going to not call it a hotel. And you know, somebody and some of your people want you to believe that a hotel and a lodge is the same thing. But you know, you can put lipstick and dress on a pig, it's still a pig. And that's bottom line. So they're trying to circumvent to get this in there. I urge you very much not to allow this. It is, I mean, you look at this, 132 rooms. That's not a guest lodge. Plus, they include 5,000 square feet of space. They include a bar. They include a restaurant, spa, and single-family dwellings. 25 units for employee housing. That doesn't mean 25 employees. That means 25 units. They could have way more than 25 employees in those units for the housing. So it's not a lodge, it's a hotel. And I urge you to not let Island Park who, some of your people, and I'm gonna say it, nobody else has said it. Some of your people who are obviously to my right, because Island Park has asked for someone to be dismissed because of their incompatibility and their inability to be fair and logical in things. And so they are helping them. You know, they are divining things and saying, oh, well, a hotel is the same.
Comments remain germane to the issue that's in front of the board.
It is germane, because if you look right here, it says, the administrator's reading has described it as the guest lodge and a hotel is the
You're
same.
dealing with, you're getting into the area of personnel matters. You want to do a personnel matters in this hearing?
It's in your paper. It's not personnel matters, it's written down.
Anything else?
So anyhow, I would thank you for your time, and please deny.
Any questions?
I doubt they have.
The next individual will be Dee Dee Draper, after which we'll take about a 10-minute break. We'll take recess the hearing for about 10 minutes, and then we'll reconvene for the rest of the public. Please proceed.
Hi, my name is Dee Dee Draper. I live at 3618 Highway 32 in Ashton. Pretty much everything I had to say has been said, specifically, but for a little bit of background, I worked dozens and dozens of hours back in, I don't know what year it was, 08, 09, when we were working on redoing the development code and comp plan at that point in time. Lots of community meetings. The rural designations were made for the reasons that we've heard of here. These are not the same thing. The developer is just coming in and changing the name around. I'm bummed out that the P&Z Commission had to spend all their time reading all of this for an application that so thoroughly should not have been put forward. The Spring Hill Suites, which we all know what that looks like, is 111 rooms. This facility is 19% larger than that, with their 132 rooms. The meeting rooms, the restaurant, the spa, and basically 2 subdivisions. 10 individual homes and then 25 units of employee housing. It just plain and simple is not, it is a hotel. It's a hotel motel. It's not the same as a guest lodge. And for me, it's no different than saying, I don't have a dog, I have a golden retriever. This is not what their code was supposed to have, and I really encourage you to uphold the P&Z Commission's hard work that they put in on this. And thanks for your time.
Thank you. Any questions from the commission? Thank you. We will now take a 10-minute break. We'll reconvene at 7 p.m. to continue with the public comment and the balance of the hearing. Thank you.
And you guys, 87 full of the travel line, right? Always 7, so if you travel that way, maybe you should find a guest lodge.